what is intellectual property. So, any brand idea, design, or other type of creation over which an individual or any business has legal rights is referred as intellectual property. In today's world, almost every company has intellectual property, and which is a valuable asset to the company or any individual which owns it. It is important to note that India has fulfilled its commitment under the TRIPS agreement, which is trade related aspects of intellectual property rights, mm, by passing the relevant legislation and revising existing legislation. So, what includes in common IP? It copyrights, patents, design, and trademark. So, copyright safeguards any written or published works, which include books, songs, web content, etc. Patents safeguard commercial invention, such as a new company's product. Design safeguards designs like drawing and IC circuits. Trademark safeguards the sign, symbol, logos, words, and sound that differentiate one company's goods from their competitors. Next slide, please. Uh, so in India, intellectual property must be registered and enforced. That is, one need to register most sort of the intellectual property rights in India if they want to use them. Individual.
Ashish, just 1 minute. You have included these three, four slides. What is the relevance of these three, four slides?
Just to discuss on what
What
is.
is IPR?
Yes.
Why do you discuss what is IPR? You're talking about the Kent system, na? Kent
The-
and Rohtak, क्या नाम है इसका? अमित
yeah,
रोहतक. तो
Rohtak.
उसी केस पे restrict करो ना. Why you are deviating from that? I think you are after 3, 4, 5 slides you are coming back to Kent. Move into that. See
Yes.
that how many are relevant slides. Skip those slides.
Okay, so we can skip this one. Next, Rishabh can take on from here.
So, I'm going to continue from the court judgment and the arguments brought by the defendant and the plaintiffs. So the plaintiffs who were Kent, they relied on rules 3 rule number 3 of the Information Technology Intermediary Guidelines Act of 2011, because in this case eBay was acting as an intermediary, as it was selling the goods which were allegedly infringed and were made by Amit Kotak. So eBay they sought protection under section 79(3) of the act, and it states that eBay cannot be held liable for any third party information, because in this case it is third party and the direct parties associated were Kent and Amit Kotak. Uh, According to the single judge, the plaintiffs who were Kent, according to the rules which they relied on, the single judge, he said that the plaintiffs can just merely compel the intermediary, who was Kent, to publicize the rules, regulations, and privacy policy, and to ensure that adequate measures are in place. That is, eBay's responsibility is to ensure that is just to ensure that any item which is allegedly infringed, it should be checked, or if it is, it should be checked before uploading, or if it has been uploaded, then they have to be removed. That's it. So the court, but eBay was asking for more than that. uh, ebay was uh, eBay was directing I'm sorry, Kent was directing eBay to check their entire product list, and to check for possible infringement, and if the infringing content existed, then they have to remove them as well, apart from the products which were actually uh, told that they were infringed by Kent. So the judge then found that the plaintiffs, they must prove and plead and prove conspiracy, abetment, or assisting within the terms of section 79(3) in order to establish a case under section 79, but they couldn't do so. So their argument was without any substance. So hence the single judge disposed of the suit against eBay and directed the plaintiffs and eBay to bear their own costs. So the basic thing was actually that Kent, they were directing eBay to check their whole content, everything they have posted, which would actually be interfering in their day-to-day operations, which was uh, and hence the suit was disposed by the judge. Uh, Pradhiman will carry on with the conclusion.
So to conclude, the IT laws say that as long as the intermediary just simply hosts the content given by end users and does not interfere, abet, or induce anything, it cannot be held liable for any of the actions held by its end users. So also the Indian legislature only requires such intermediaries to tell its users about the policies that it has and to advise them to not infringe upon anyone's intellectual property, but it cannot act on its own and delete their content as long as there is no complaint from a aggrieved right holder, in which case they have to delete the content within 36 hours of reception of a complaint. They cannot filter every piece of information hosted on their portal for possible infringement, as it requires them to assume the role of a self determining authority and requires them to uh, just judge if there is some sort of intellectual property infringement on their own, and which is not authorized by law to an intermediary. So that's
Here
it.
is the references which the
You
sites
have,
which we consulted for making the term paper.
yes, that's,
Thank you.
thank you.
Thank you. Okay. Who's the next?
Group number 1.
Can we start? Good afternoon, everyone. I am Priyanshi, and we are going to present our term paper on the Diamond versus Chakravarti case of 1980, which was a US Supreme Court case in which it granted Anand M. Chakravarti and his employer General Electric a patent on the microorganism that he had modified to consume hydrocarbon. Next slide. This case was won by 5-4 majority, with the Chief Justice held that human-made bacterium could be patented under the patent laws of United States, but because such an invention constituted a manufacture or composition of matter. Next slide. A little about the background of the case. This case was highly contested, and both sides incorporated into their arguments a critical statutory precedent, that is the Plant Patent Act of 1930, PPA. The PPA granted patent protection to plants that were asexually reproduced, which meant mainly fruit tree vines and flowers such as roses, that if any variety of which can be identically propagated from. The PPA was made to overcome the key obstacles of the doctrine that was first fully articulated in 1889, that the products of nature were ineligible for patents. The reason it being, as the commissioner then stated, that to be eligible for a patent, the object must be made by a human being and not by nature. Next slide. Okay. The PPA 1930 was the first statute anywhere in the world to extend patent protection to class of living organisms. It authorized a patent to anyone who has invented or discovered and asexually reproduced any distinct and new variety of plants other than tuber propagated plant. Next slide. The PVPA, that is the Plant Variety Protection Act of 1970. The PVPA gives breeders up to 25 years of exclusive control over the new, distinct, uniform, and stable sexually reproduced or tuber propagated plant varieties. A major expression of plant breeders' rights in United States, the PVPA grants protection similar to that available through patents, but these legal schemes differ in critical aspects. Next slide. Difference between PVPA and PPA. The PVPA and PPA provide protection based on different types of plant reproductive strategies. The PVPA, which authorizes plant variety protection certificates, protects sexually reproduced, whereas PPA, which authorizes plants patents, is limited to asexually reproduced plants. However, the same plant may be protected under both PVPA and PPA. The most appropriate means of protection may be decided by the applicant based on the applicant's business requirements. Now, Tanupriya will continue from here on.
Good afternoon. I'll be discussing about the discovery of bacterium known as Pseudomonas putida. Anandan Chakrabarti was a genetic engineer who worked for Research and Development Center at General Electric Company, New York. He developed a bacterium which is capable of metabolizing the hydrocarbon that constitutes the crude oil, which he proposed to use in treating oil spill. Next slide, please. What was the process of manufacturing the bacteria? At that time, four more species of oil metabolizing bacteria were known to exist, but when introduced to an oil spill, they competed with each other, limiting the amount of crude oil they have degraded. The genes necessary to degrade oil were carried on plasmids, which could be transferred among species. By irradiating the transferred organism with UV light after plasmid transfer, Professor Chakrabarti discovered a method of genetic cross-linking that fixed all four plasmid genes in place and produced a new stable bacteria known as Pseudomonas putida. Uh, a prior method had to rely on a mixture of bacterial strain, each of which acted on a different set of hydrocarbon components. Unfortunately, not all the bacterial strain could thrive in various invention condition existing in the area of oil spill, so that when the mixture of bacterial strain was used, only some of the bacteria survived long enough to attack the spill. Plasmid control the oil degradation ability of certain bacteria. He developed a process by which multiple plasmid capable of degrading different hydrocarbon components could be incorporated within a particularly hardy single bacterium. This genetically engineered bacterium was capable of breaking down oil spill at a much faster rate than the naturally occurring bacteria. Uh, New bacteria were not product of nature because Pseudomonas bacteria containing two or more different energy generating plasmids are not naturally occurring. The research group of Anandam Chakrabarti found out that Pseudomonas aeruginosa, a bacterial species, secretes the toxin for gazillion, which kills cancer cells for digesting oil to fight cancer. Next slide, please. Chakrabarti's 1972 patent application claim directed to the method of producing the bacterium, an inoculum composed of a carrier material and the bacterium and the genetically engineered bacteria itself. Now Gaurav will continue.
So you are muted.
Chakrabarti filed three types of claims. Only the claims related to the bacteria themselves were rejected. Then he appealed at the Patent Office of Board of Appeals. They also rejected the claims because 1930 Act does not intend to cover the living organism. After the rejection, Chakrabarti appealed at Court of Customs and Patent Appeal, which held that the fact that microorganisms are alive is without significance. They reversed the prior decision. Acting Commissioner of Patent and Trademark filed for the petition for certiorari. They re-examined the case and reaffirmed its judgment. The Commissioner of Patent and Trademark again sought certiorari. Since then, Supreme Court dismissed the petitioner as moot, ruling in favor of Chakrabarti. The major question asked by the petitioner was, respondent's microorganism constitutes a manufacture or composition of matter within the meaning of statute. Hearings that helped, unless otherwise defined, words will be interpreted as taking their ordinary and contemporary common meaning. Second, court should not read into the patent law limitation and condition which legislation has not expressed. He manufacture and composition of matter meanings were defined. In choosing such expensive terms as manufacture and composition of matter modified by the comprehensive NE, the Congress plainly contemplated that the patent law would be given a wide scope. Petition arguments were manufacture and composition matter both does not include living beings. If they did, 1930 Plant Patent Act and 1974 Plant Protection Act would not be necessary. Second, microorganisms can't qualify as patentable until unless Congress explicitly authorized so. Supreme Court rejects petitioner's first argument. Plants were not thought of amendable to written description. Therefore, 1930 Act relaxed the written description requirement in a favor of description as complete as reasonably possible. Second, SC rejects the petition's second argument. Once the Congress has spoken, it is the duty of the judicial department to say what the law is. Broad general language is not necessarily ambiguous when congressional objectives require broad terms. This is especially true in the field of patent law. A rule that unanticipated inventions are without protection would conflict with the core concept of patent law that anticipation undermines patentability. The conclusion by Supreme Court: Congress intended the statutory subject matter to include anything under the sun that is made by men to be patentable. And Mr. Chakrabarti was granted a patent because uh, for his significant discovery, and no characteristics of bacteria of such is found in nature. Now Aman will continue.
Just 1 minute. ये जो इसमें आपने बोल्ड में लिखा है ना, एनीथिंग अंडर द सन दैट इज मेड बाय द मैन, men, women, both, it includes both. So this is something which has become so famous world over. Anything made by man under the sun, है ना? And just to tell you that Anand Chakravarti, he came to our class about 15 years, 17, 16, 17 years back. 18 years back, he came to our department in the class. He came to IPR class, and last year, unfortunately, he died. So it is one of the most famous cases in IP. Okay.
Yes.
Please continue.
Okay.
Yeah, good afternoon, guys. Moving upon to implication, we will discuss how Diamond versus Chakravarti case, as which stated anything under the sun that is made by man is patentable, affected the society, mainly biotechnological industries. We are going to look three case studies which highlight the importance of creating the biotech industry. So yeah, next slide, please. So yeah, in the first case, we are going to discuss how genetically modified crops, genetically engineered crops, actually grown up. As a conclusion of this case, it was observed that the traits which are found in GMS and GMOs are not natural to the native species. So the plants and their alterations are considered to be man-made organisms, and thus can be patented under Chakravarti Act. So in 1990s and 1993, Dr. Dilip Sa and other of Monsanto company filed patent, and it also proved to be a breakthrough to develop and commercialize genetically modified seed. So yeah, next slide, please. So yeah, after the patenting of seeds by various agri-tech company, it was observed that Monsanto itself in 2017 earned a yearly sale of $10.4 billion, and it is also observed that a study is done in 2014, which also showed that genetically engineered crops also reduce use of chemical pesticide by 37%, and also an increase in farmers profit by 68%, which is huge large. So we can say that Chakravarti created necessary incentives and protection for researcher to create genetically engineered crops that is feeding world today. So next slide, please. Yeah, the second case which we are going to discuss is a polymerized chain reaction. Actually, PCR is an extensively used technology in research laboratory and medical diagnostics. This technique of efficient DNA sequencing was even a breakthrough for the society as well as for CETUS Corporation. Because in 1992, the CETUS Corporation itself sold their PCR technology rights around $300 million, and the inventor himself got Nobel Prize. So this is the things which can't be possible without this decision of Supreme Court of Chakravarti Act. And the third case, next slide, please. Yeah, and in the third case, we are going to discuss a monoclonal antibody therapy. Actually, as we know, antibodies are antibodies are those which identify and attack pathogens, and monoclonal antibodies are used in the treatment of diseases like cancer and other inflammatory diseases. And there are several companies like Genentech of USA who done the patent of these monoclonal antibody therapy, and they earned a huge profit from that. So
Can I ask a
moving.
question? Actually, it is genetic or Genentech.
Genentech, sorry.
Actually, I know about this company, and perhaps it is Genentech, I think also. Okay, so you can go ahead.
Okay, thank you. Yeah. So moving upon to our next slide of implications. Yeah, 6 on. Yeah. If we talk in terms of money and revenue created after this act, it can be seen that overall the size of monoclonal antibody therapeutic industry in 2017 was estimated around $95 billion, which is quite large. And other medicines also proved by World Health Organization like Avastin, which have $7.1 billion, and Humira for arthritis, $18.4 billion. I am quoting this data to show the significance of this act, which created in the human society. So yeah, moving upon our last slide, we are going to see how Diamond and Chakravarti case have a broader implications over the society. Like today in United Nations, firms like Pfizer and Moderna are leaders in diverse field of biotech companies. And in fact, we can say worldwide, the biotechnological industry have a revenue of $300 billion. So we without doubt can say that Diamond and Chakravarti case revolutionized the biotechnological industry and society as whole, and it will proved and it is yet proved, and it will be proved as one of the most beneficial decision of humankind. Yeah, sir. Thank you.
Thank you. Very well presented with a lot of details. Good homework done.
Thank you, sir.
In fact,
Thank you, sir.
when he came, it was, I think, 2003 when Diamond Chakravarti came here. This Anand Chakravarti came here, and at that time, our mobile did not have a camera in it. It was an evening class, 6 o'clock to 9 o'clock. So, we could not take the picture at that time. It was one of the most eminent persons in the world came to our department, and in fact, he did not come to the department there such. He came to the class directly.
Oh,
So,
nice, sir.
okay, thank you.
Thank you, sir.
Okay,
Okay,
bye.
thank you.
Thank you, sir.
Next. Now, the next is the एक मिनट कितना रह गया 1 2 3 4 5 6 should we take one more, or should we take one more? We can take only one more today now.
Sir, when will the like
Monday, परसों की क्लास
next
में
slot happen?
परसों की क्लास में बाकी कंप्लीट करना है. 6 लोग रह गए हैं. 3 4
1 2 3 4 5 6 7 sir, 8 presentations are left, sir.
8 या कितने में according to me?
No,
1 2 3 4 5 6 7 7 रह गए हैं अभी. 8, हाँ, number 1 is also there, right. 8 are there. तो एक presentation आज करते हैं. 7 we'll do it on Monday.
okay, sir.
Okay.
Okay, sir.
Today's last presentation.
Can group give a presentation right now?
Yes, please. Group number 2.
You were planning to group 3. It was our turn. So, can we start with our presentation, group number 3?
Group number
3.
Huh?
Group number 3.
3.
Group number 3, 1 minute.
Oh.
Coca-Cola.
Yes, sir.
Distillery. Okay.
So, yeah, we are a group of 4 people, with my partners being Sayyam, Pranit and Shashwat. So we selected Coca-Cola Company versus Distillery International as a case study, and it is an intellectual property rights, and it was kind of a basic setting for Indian intellectual property rights, also popularly known as the Maza War. Next slide, please. So yeah, what happened was the plaintiff, being Coca-Cola and Maza, both being very big companies, had a dispute over their trademark sold by Bisleri earlier to the Coca-Cola company, Maza. So there was a legal fight over it. Next slide, please. So uh, the uh, Bisleri company, part of Parley Group, and earlier known as Aqua Mineral Private Limited, sold intellectual property rights for five companies: the Citra, Goldsport, Limca, Thumbs Up, and Maza, to the Coca-Cola company back, uh, and to make the deal worth the money. Many documents were signed, like goodwill assignment, know-how, confidential, non-use agreement, non-compete agreement, etc., were signed. So to make the value worth it, and the Coca-Cola company at that time was an established brand with drinks operating in over 200 countries at that time. Next slide. The They sold the rights to sell Maza products in India. The right to sell any of the five companies' product in India to Coca-Cola company, but retained the right to sell their products in other countries. But in March 2008, the Coca-Cola company filed an application for registration of trademark Maza in Turkey, and the Bisleri company retaliated by sending a legal notice on September 7, 2008 to the Coca-Cola company. But in return, the Coca-Cola company sued Bisleri for violating the agreement terms by many irrevocable and absolute right embarked upon the plaintiff. So, and they also, what they alleged, that they were selling the products in Turkey via Aqua Minerals, and had allowed intervention by third parties companies such as Verma International and MS India Canning Industries. They were manufacturing products in India and then exporting them to Turkey to sell, which under Indian rights, which under Indian law wasn't allowed for them to do so, because it fall as an Indian product, not as a Turkey product. And the Coca-Cola company had rights over manufacturing and selling all products of under the trademark Maza in India. So from now, Pranit will carry forward.
Yeah. So some of the issues that were raised during this case were that whether the plaintiff, that is the Coca-Cola company, was entitled to get a permanent injunction against Aqua Minerals. The second one was that whether the export of the products with the trademark Maza, that was the Maza War, could have been considered as an infringement in the exporting country. The third one was that the Delhi High Court, under which the judgment was taking place, had the jurisdiction to take up the matter in this particular case. The fourth one being that was there any infringement of a trademark or copyright. And the last of the issues raised were that whether Verma International versus Indian Canning Industries should have been considered as a party in this case. These were all the issues raised in this case. So pertaining to these issues raised, there were two provisions in the law that were prominent during the case. They were sections 41H and 41I of the Special Relief Act 1993, which basically state that since there was a detrimental contact between the two parties, that is the plaintiff and the defendant, the Coca-Cola company and Bisleri, the suit could not be barred according to these sections, which entitled the plaintiff, that is the Coca-Cola company, to get a permanent injunction in order to fulfill their exclusive rights. The second one was Section 42 of the Special Relief Act 1993. It states that in courts, the plaintiff will be entitled to the injunction if they had performed their part of the contract as was binding on them. This meant that the plaintiff, the Coca-Cola company, will get an injunction if it has done or completed any part of the contract. From now on, Shashwat will continue.
Sure, Pranit. So now let's get to the judgment. So one of the most interesting things of this of this case was that the defendant Bisleri actually tried to complain that the court did not have jurisdiction over this case, which was absolutely not the case, because anything which is manufactured in India and even sold outside is considered as a sale in India, and that's why the court did have did have jurisdiction over this case, and they went forward with giving the sales. So what the court finally came to the conclusion was that uh, what they gave as the judgment was that the Bisleri sales of Mazda products in India had been are being banned, and they gave an interim junction banning the defendant, that is Bisleri, to sell any Mazda products even outside India, because anything which is exported is also considered as a sale within the country. So if something is manufactured in India and then exported and then sold in, for example, Australia, then that is also considered as a sale in India, and that comes under the trademark of India, which is actually owned by the plaintiff, that is Coca-Cola. And it was also found, it was very interesting that it was also found that Bisleri was already doing this. They were already selling Mazda products outside in India in Australia through Verma. Can I move to the next slide, please? Yeah, they were already making Verma International a party of this case. They were already selling this, and this was illegal. So that is what the court found, and they gave the decision that this is not allowed, and any products which are made within India can be sold only within the country. And so they give this interim injunction, and that all rights were with Coca-Cola itself. So. Uh, yeah, so that was all from the judgment. Uh, and so the absence also, then further discussing upon it, it was found that the absence of a provision for the recipient of third level domain to determine eligibility of the dominant does not apply, that registration alone confers a right or legal interest in the domain name. So yeah, I think the case was totally gone towards Coca-Cola, and because anything and I think the main point to be noted by the court was that anything which is exported is actually considered as a sale within the country itself, so within India itself, and that trademark lies with Coca-Cola. So yeah, that's all. You can move to the next slide, Gunjit.
Yeah, sure. So I will continue with the presentation. So till now we have gotten to know about the facts and the judgment that was given by the court, and now we will give you the analysis and the discussion and the conclusion that we have drawn from this case. So like in terms of the criminal law, the IPC has extraterritorial jurisdictions. This means that an Indian citizen can be held accountable for an offense committed on a foreign land. And in this case that we have, the Delhi High Court has authority to hear the case. The defendant's company appeal against the order was dismissed by the Delhi High Court initially. Basically, selling of Mazda goods in India was explicitly prohibited by the court, which means that the court explicitly said that you cannot really sell the goods in India, which was true from the case that the agreement that they had earlier. And in order to avoid the plaintiff from incurring irreparable loss, an interim order of injunction was passed that they could not really produce the Mazda goods and could not really sell in India or even export it outside. And because of Missionaries, manufacturing was for export, and Missionaries still had the right to sell the goods in other countries, the court should have issued an injunction solely for sales in India and not for exports. The fact that court actually gave the order that you cannot really sell even outside India actually led to a lot of losses for Bisleri, which was a great disadvantage in this case. And Bisleri also had registered the trademark Mazda on a global scale, which should have allowed it to market the product all over the world. The Coca-Cola sale had secured the trademark for its sale only in the Indian subcontinent and is now attempting to expand its search globally. Their assertion of an injunction on the manufacture of goods for export is unwarranted. The court should have permitted the case to proceed in part because of its sale in India. And now we will come to the conclusions and suggestions that we have here. Like in this case, it was concluded that the trademark is one of the various aspects of intellectual property rights. It covers brand name and business related aspects. Any individual or company who uses the same name or concept as others to get benefited from their product and goodwill are an infringer of the trademark. The defendant company was right when it sent a notice to the plaintiff regarding the breach and also the company's intention to restore things back as it was before the agreement. A breach of an agreement must be strictly dealt with. The defendant company should be appreciated for its bold step to such a strong step that no one can be held with a breach. The court should have upheld the same and must have ruled in favor of the defendants. As we know that every judge has his own opinion and pronounces the judgment accordingly, we see that the judge in the above cases also did the case accordingly in his own view. And the case proved that trademark rights are globally recognized and the law protects the rights of the owners of these trademarks. Thus, in this case, is considered as a major contributor to the development of intellectual property rights in India. And now we'll come to the references where we have used to prepare our presentation. And yes, so Ramesh.
Okay, good. Only 2 points I want to ask. One is that in the conclusion, what do you say about the original agreement with Coke by the Parle Agro that they can use, they will have the rights of these brands in India and not abroad? So that itself was wrong. This is what you said, no?
So the agreement, according to the agreement, the Parle Group could sell any product under those brand names outside of India, and the Coca-Cola company had exclusive rights to sell them in India. That was
But now what the court held finally that what you're saying is the uh, the, the the company which is making these brands in India can also export it. So when they export it, it will be in there is conflict in the other countries like Turkey and all these things. No. So what is your final conclusion about it?
that was the dispute. What Parle did was using Burma International and subsidiary companies, they manufactured products in India and exported them to Turkey. So under Indian law, it was considered as a sale in India instead of as a sale in Turkey. But
Okay.
so
So that is
that
what I think I missed that part. So it was not doing it itself, no?
no, they were not selling; they were manufacturing them using Burma International and Indian canning companies, which was considered as a sale in India according to the law, but it should have been considered as a sale in Turkey according to us because it wasn't actually they were actually selling them there.
Okay, good. So thank you very much. And
Thank you,
the
sir.
remaining
Thank
ones
you, sir.
will have in the term paper group number 6, 2, 4, 5, 6, 8, 11, and 16. We'll have on Monday. Okay.
Sir, and can you please share the attendance record? You have
Uh,
said that you will share on
Share it.
Monday.
Dr.
Share
Jishan,
it.
have you
No,
shared
sir.
it with all
No, sir. I will share it
today?
by
Today evening or
today or by
tomorrow?
tomorrow. By tomorrow, definitely you will get that. Know your attendance.
He will be preparing it. And those who have attended today, they get 4 hours for attendance. Okay.
Sir, this
Uh,
is Himanshu from Group 4. So, what will be the schedule for presentations on Monday? Will it be
uh,
happening during the class?
yes, during the class. Because
Okay.
for the GI, we'll have to have some other session. We'll decide in the class. Okay.
Okay, sir. Thank you.
Right. Thank you. All the best.
Thank you, sir.